So today we're going to talk about habeas corpus. It is a little known process that a lot of people are using nowadays to get their loved one out of jail. So if your husband, your mom, your spouse is detained right now and an immigration judge says there's no bond available or doesn't grant a bond when they should, then we go to federal court to get a second opinion, if you will, to see if we can get them out of jail. It's been working pretty consistently. Today, we're going to talk about some of the ins and outs of habeas corpus.
Yeah. Hi.
Marina.
Yeah, hi. So let's start with the basics. Habeas is usually associated with criminal law. So why and how did it become a tool in immigration cases?
Right. Well, it's a very recent tool. We've never used this in the past. We've been doing this almost 2 decades until this year, for the most part. And we've had to use it because we need to go to the federal courts to enforce federal law against the immigration courts. See, a lot of people don't know that the immigration courts are actually operated by the Department of Justice. They're not entirely independent. And so by going to this federal court, we get an independent judge that enforces the law and makes them do their job at the immigration court, which is often doing a bond hearing.
I have a specific question about trigger. Probably it's the most important question for anyone watching this, because when exactly can you file habeas? What is the trigger? So my question is, what specifically are you challenging in that petition?
Well, each case is a little bit different, of course, right? So you have some people that have been detained a long time without a hearing. That's kind of a special category that's pretty strong. Usually 6 months or more if you've been detained. That's a big trigger. Then you could go under what they call a Zabadivas case, and we could challenge based on that. Other people are detained and they're told that they get no bond hearing. We've had a lot of success with what they call re-detention. So somebody came to the country, they applied for asylum, they were detained for a day or two, but then they were let go. Now, 2 years later, 3 years later, they get picked up for nothing, right? And are detained without a hearing. So that's called a re-detention case. And that's often a trigger. You have other people that came into the country without inspection that are picked up, and they're entitled to a bond hearing, but not given one. And then, of course, you have people that actually came with some sort of visa and overstayed that aren't given a bond hearing, and they're entitled to one. So sometimes the federal court has to make the immigration court do their job and honor the law when it comes to these hearings.
Okay, you mentioned 6, 7 months. Okay, once you file, how long it does typically take to get a response from the court? So,
well, you'll get an acknowledgement right away, and we've seen people released in a week or two. It happens, right? But we also have cases that have gone on now a couple of months where that's getting drawn out as long as possible. So, for example, today, the government did a filing on one of our cases. Now, this is a really strong case. This person's been detained after they've won their case for well over 6 months. It's wrong. They should be let out by a matter of law. And so we did the filing in early February, and then the judge finally reviewed it like a month later and then gave the government time to reply. Today was the last date that the government could reply, the very last day. And of course they did. So now we have to reply to the government with our response to their motion called a traverse. And then hopefully once we file that, which will probably take one day, we're pretty fast about these things, the judge will hopefully rule within the next couple of weeks on the case itself. So that's an example of a long case that will probably take about 3 months from start to finish.
Okay, in general, how complicated the process?
It's very complicated.
Why?
Unlike an immigration case where you're going in and saying, hey, this person has connections to the community, they're not criminals, they have somewhere to live, and it's pretty straightforward. When you're doing a habeas case, you're citing case law and statutes, oftentimes, maybe 50 or more case citations that apply to that district, to that person, to that set of circumstances. And it's very, very complicated. It's much more complicated legal writing than dealing with the immigration court. And so that takes a little bit of time to put together. We're pretty quick about it, but every district is also different, every circuit. So if we're filing in Texas, it's different than filing in California. It's different than filing in New York or Pennsylvania or any of the other many states that we file in. Each one has its own set of law and judicial opinions that we have to comply with. So it's really a challenge. Thankfully, we've had a lot of success this year. Thus far in 2026, every case has been decided in our favor. At some point, of course, that ends, but so far so good.
I don't think I have any other questions. I had them, but you already, you already know.
Yeah, I tried to cover it. So, look, the typical call, like typical intake we get, as you know, because you take a lot of these calls, is that somebody will say, okay, I have a loved one that's been detained for no reason, right? And so first we have to uncover why they were detained, right? And part of that process, we also have to figure out how they entered the country exactly. If they were released after they entered the country, have they done anything in the meantime? Have they filed a case for asylum, for example? We have to compile all this information about their entire existence in the United States from the moment they step foot here until now. Then we have to look at the circuit where they're held. We have to first file in the proper jurisdiction and say, hey, judge, make the government keep them where they're at. Don't let them move them, because if they move them, then we have to start all the way over. So we create an order right from the get-go that says no movement. We're going to argue the case here. Don't play games with the client, right? And then we do the first filing once we have all the information together, and that starts the process and it moves it forward. And so many of the times that we're contacted, there's not relief, or it's in a jurisdiction that's very difficult. So let's say, for example, Louisiana, right? Louisiana is very difficult because they follow the Fifth Circuit and they have their own specific set of precedents that they've had from their judges. So it's very difficult and very slow to get anybody out. Right now, there's arguments to be made and you can be successful there, but it's not going to be quick and it's not going to be easy. And so many people approach us with that, and we'll tell them from the beginning, look, we could do it, but you maybe have a 10% chance. So
10 is not that bad.
10's not bad, but it's not, greater than 50% have they, we're sitting here in the San Diego office today. If somebody comes in today and say, I have a loved one in Otay Mesa Detention Center and we want to get him out, and, lays out the circumstances, it's not a guarantee, but it's a very high probability we're going to get them out, right? If there's anything going on. So it's very different. So then the, potential client has to decide, is this worth the money to try, or are we just going to fight the case in court? Because it happens pretty quick once you're detained. Yeah. And so we find ourselves, as you know, helping people that need removal defense quicker than expected. So, for example, a case that I filed yesterday, this person had court in 2029, right? So at least 3+ years from now was going to be their first hearing. Okay. Now they've moved it to where they want a final hearing within the next 30 days because they're detained. So we're doing the habeas for them, but we've also had to take over removal defense as well because there's no time. We have to prepare for both. We have to try to win the case and win habeas. And this is how they have to proceed, And so lots of times people want to come to us and say, oh, let's just do habeas, but that's not wise. When you have a hearing 30 days out.
It's placebo, right?
Yeah. When you're detained, the odds of you being successful drop, whereas like historically, the odds of winning asylum in general are about 30-35%. If you're detained, it's 80 or 90% you're not going to win, right? And so obviously that's not the case with our law firm, but those are the general statistics for the United States. So you have to be ready. You have judges that are not as friendly as some of the other judges. And they do this on purpose, the way that they put people in Louisiana, for example. There's a reason, and there's a reason there's certain judges there. Yeah. It's a tough deal, but...
Okay, so may you please make a conclusion?
Yeah.
Something optimistic, like it's not for everyone, but if we're gonna tell you that we can take it, the chances are.
Yeah. So if you're interested in habeas, you could reach out to us. We're going to give you a short form or ask you some questions over the phone and see if we can help you. We're not going to take the case if we can't help. We don't want you to waste money. We don't want to build hope where there's none to be had. But most of the time, we can help and give a legitimate chance of getting out on habeas corpus. And so a lot of people think, though, that habeas is the absolute solution for everything. And what it does is it actually opens the door to a solution. It's not always the end solution. So sometimes when you win the case for habeas, the person's automatically released. Most of the time, however, they're granted a bond hearing. So then you could go back into the immigration court and to the immigration judge and say, now look, we have an order from a federal judge that says you must give a bond hearing. And sometimes it makes the bond hearing a little easier. Sometimes it's just a normal bond hearing, but you get your day in court. And if you get your day in court and you have, let's say, U.S. citizen relatives, or you have a steady job, or you have a place to live, and you have no criminal history, and you have a strong case, and maybe you've hired a lawyer to help you with that case, if these things that are the merits of your case or outweigh the downside to you being a flight risk, most of the time you'll be released on bond. So that's how habeas usually works. It's worth looking at. We'll give you a free review. Fill out a short form. It'll take you 5 or 10 minutes. Give us the information. We'll go through it and we'll give you an answer one way or another.
Okay. Thank you.
All right.